Case number 106807, State of Kansas v. Reed.
May it please the court, Richard Ney appearing for the appellant in this case, Samuel Reed. Mr. Chief Justice, I would request 3 minutes of time for rebuttal.
3 minutes is granted.
Thank you. Samuel Reed was tried for attempted first-degree murder, and part of the proceedings that led to his convictions were closed by the court, closed to the public. The courtroom doors were locked. And that was done without any Waller findings at all at that point in time. There were some post hoc findings at the motion for new trial, and it was done without clearly the consultation or consent of Mr. Reed, the defendant. We'd submit that the Court of Appeals, in deciding this case, used an erroneous standard. Clearly an erroneous standard when this court ruled in State v. Cox, 4 months after the Court of Appeals opinion here, that one, there can be no harmless error analysis in a closed courtroom situation. And the Court of Appeals applied a harmless error analysis in its discussion of this case. And secondly, that the court would not, this court said it is inappropriate for a judge to do this kind of post hoc, after the fact, Waller determination. So clearly, the closure of the courtroom here was error, structural error. The defendant did not have to prove prejudice. And one could wonder how prejudice can be proved in that situation. And that's what this court said under Cox. And that Judge Burgess at the motion for new trial / post-conviction motion could not make the Waller findings in retrospect.
Mr. Ney,
yes.
All of that argument depends upon seeing this as a closure rather than like a sidebar or a consideration of a legal argument in chambers. That sort of situation. I mean, there are situations that occur after trial begins where it doesn't have to be public or it doesn't have to be in the presence of everyone in the courtroom. So how do we draw that line? Well, and why wouldn't we not draw it here?
Right. This case, I think it's easy to draw. We're not talking about maybe a discussion about a jury instruction that was done in chambers. What happened here was the critical witness in the case, Amos Becknell, the only person to identify my client as the shooter, was questioned about his willingness to testify. That, I would submit, was the most critical thing that happened in the courtroom in this case. That whole determination that he was unavailable and that he wouldn't testify, as I want to talk about in a second issue. But that was the most critical thing. This was not something mundane. It was not something offhand. It was critical. And it was done in the courtroom with Mr. Becknell administered the oath on the witness stand, but the courtroom doors locked.
That critical result versus critical stage, there's a distinction. There's a lot of things that happen at the bench where you get hammered on an evidentiary ruling that you've lost your case, basically. So I think that's no answer to just say that it was critical to the defense. The question is, why was it a critical stage of the proceedings as we understand that to be?
Thank you, Your Honor. Well, let me put it this way. Would the court have been fine, Justice Johnson, would you have been okay if my client had been excluded from the conversation, or not the conversation, the attempted testimony of Mr. Becknell? I would suggest no. If this is not something we would say, oh, it's just sort of pro forma, something at the sidebar, we could exclude the client. How can we exclude the public? I think that's the same line that we need to be drawn here. And I think it was absolutely critical from the standpoint that this set the tone for the rest of the trial, that he was going to be allowed to walk out of the courtroom and not testify, and his preliminary hearing testimony used.
Can I clarify?
Sir.
You're saying that if the situation would not permit the exclusion of the defendant, then it doesn't permit the exclusion of the public.
Yes, I think that's a way to draw this line.
So all the jury trials where we go into chambers and bring people in to give their excuses, that was actually a violation of public trial?
Well, I think there's certainly an argument to this, and this court has talked about addressing jurors even. Jury questions have to be in public in front of the defendant now. But let's look at another way. Let's compare this to Dixon. Okay? Why was Dixon, or what stage was Dixon closed? To read the verdict. I've got to tell you, as a trial attorney, there's nothing less critical in the sense everything has been done. That is just a ministerial act. We're going to read the verdict in open court. Jury's decided. The case is over. We just don't know what the result is yet. Only the 12 people on the jury did. But in Dixon, it was said, hold on, no. You cannot close the courtroom at that time. And if we're going to say Dixon is on the other side of the line, Justice Breyer, how could this not be on the other side of that line? And what's interesting, too, is that when Becknell testified at the preliminary hearing, which was later used as his trial testimony, that was an open courtroom. There was no need seen to close the courtroom at that time. So one.
I have one other
Yes.
question, and this is just a fact question. It seems like there's some dispute with the Court of Appeals characterization of how the closure came to be. As I recall, the Court of Appeals opinion says that it was suggested by defense counsel.
Yes.
And I know that you're taking issue with lots of the behavior of defense counsel, but it sounded like you disagreed with that characterization in your reply brief.
Yeah, very much so, Your Honor. And here's the transcript of that. The prosecutor actually, Mr. Phelps, the prosecutor says, look, he's not even willing to come in here. We need to get rid of the spectators. He says, take the witness stand even to say his refusal to testify. Phelps says, the prosecutor, if necessary, I want to know if the court or Mr. Pittman is willing to go to the library, the law library where Mr. Becknell is, in order to get that on the record. The court then says, well, I have no preference. I mean, obviously I'm able to do that. Mr. Pittman obviously represents the defendant in this case, and it's the defendant's rights that have to be addressed and afforded him. So, Mr. Pittman, what say you on that particular issue? Again, the question is not being put to him, do you object? It's, what about going into the library? And Mr. Pittman says, it might be easier if we just emptied the courtroom than did it here. So, Your Honor, it's sort of like if you ask me, do you want fried eggs or poached eggs? And then say, I said I wanted eggs. Mr. Pittman is giving a choice of the library or the courtroom. That's the only question that's being posed there, and that's the only thing he is asked by the court about closing this courtroom. So I suggest that is not an invitation. It is just a response to the court saying, well, Mr. Phelps is saying the library, what say you? So I don't characterize it that way. And again, of course, we're raising an ineffectiveness claim based on that as well, but under City of Wichita versus Bannon, I think it's clear that this is something counsel cannot waive for his client. He can't waive a jury trial. Can he waive a public trial? There is nothing in the record, not a word in the record of Mr. Reed ever being consulted by the court about this. Is it okay with you, Mr. Reed? And Mr. Pittman's testified he never consulted him.
In what amounted to the ineffective assistance of counsel hearing, whether it's motion for new trial or 1507, we can argue about, but that he testified he didn't talk to him about it. But the law isn't crystal clear on the necessity of that, is it?
Well, we would say the Bannon case says counsel cannot waive fundamental rights. Yes, I might be able to decide what questions to ask the witness, but it's not my choice whether my client has a jury trial or a bench trial. It's my client's right. I'd say there's nothing more fundamental, or at least on equal standard as a jury trial right, is the public right to a public trial. We're saying that's something an attorney can waive for his client? I suggest that's not true. And then we have, of course, Mr. Pittman making no objection, but also not agreeing necessarily to the using of this testimony once Mr. Becknell supposedly says he won't testify. And that's really our second issue that we'd want to talk about today. That was an error by the court, that my client was deprived of his right of confrontation. Because Mr. Becknell was never told by this court, and Judge Burgess admits in his ruling, he says, I acknowledge the words that were spoken at that proceeding, that there was no contempt sanction ordered. I would arguably acknowledge that there was no specific direct order for him to testify. Judge Burgess is saying that. What happens on the witness stand says, what if I were to order you to testify? Becknell says, well, I don't think I should have to. He says, okay, goodbye. Then defense counsel is asked, what's your position? He says, I'm not prepared to answer that at this point. And the court never comes back to it. And Mr. Pittman never makes an objection. Again, this was the critical testimony of the case that came in from the preliminary hearing. And if you look at the preliminary hearing transcript, which you have as part of the trial, because it was read, Mr. Pittman asked about 10 questions. It's about 2 pages of transcript, 2.5 pages of transcript. He admits that the post-conviction hearing, motion for new trial, Mr. Pittman admits, I didn't even have the reports. I didn't even have Mr. Becknell's statement to cross-examine him. So he was woefully unprepared to do that. And we went in at that time all the things he might have cross-examined him about. We would submit that Mr. Reed here was denied a fair trial, a constitutional trial, by the closure of this courtroom without any inquiry by this court, and by use of this testimony from the prelim, without his consent, without any true findings, any order, and we of course cite this court to the Jefferson case, order that he submit his testimony. And remember, when the judge of the preliminary hearing ordered him to do the same thing, look, you're going to go to jail if you don't testify, he testified. So one would think that would have been effective with Mr. Becknell. I will submit the remainder of our 5 issues to the court and reserve my time.
On that subject, I think you only had 3 issues in your petition for review. Is that right? Didn't you pare down your issues in your petition for review?
I believe we pared them down.
Okay, all right.
Yes,
You
Your
just
Honor.
mentioned 5, and so I wanted to be clear on that. Okay, thank you.
And I think there's the cumulative issue, but thank you, Your Honor.
Any more questions? Thank you, counsel.
May it please the court, Assistant District Attorney Boyd Ishwood on behalf of the state of Kansas. It's a little bit different since both petitions have been granted. I'd like to address the portions of my petition first, if I may, unless the court has other plans for me, which is fine as well. Of course, my petition starts with the beginning, which is Holt and the statutory authority, and whether the district court even had jurisdiction to entertain Mr. Ney's late motion for a new trial, which alleged all of the ineffective assistance of counsel claims.
Why is it a jurisdictional problem rather than a procedural issue?
Well, I think under Holt, it becomes a jurisdictional issue because the district court didn't have the ability to reach the merits of the claim because it was out of time. If that's not what, I guess if that's not what Holt means and that's not what the statute means, then the only question I'm left with is what does it mean? If it doesn't mean that you can't do it, then what does it mean and why is it there? And why did this court interpret it the way it did in Holt? I mean, it's important, at least from my perspective, it's important to realize, of course, that it's not that the defendant isn't going to be able to make these claims. It's just when he'll be able to make these claims. And this is sometimes, at least in my experience, where things get a little bit frustrating and difficult to understand when we take things out of order. The legislature has provided us with an orderly events of how these issues can be addressed, and we chip away at the clear statutory provisions that speak to that order, and we
Let's-
find exceptions.
Let's revisit something you just said, and that was that he's obviously going to be able to address them at some point if he wants to. Had the notice of appeal already been filed, then the appropriate procedure, because it hadn't been filed.
Right,
at the time
I
of
thought it was a
submission.
question, I'm sorry.
Well, we're getting there. I'm
Right.
doing the setup. At the time this motion or supplemental motion for new trial was filed by Mr. Ney, the time for a motion for new trial had expired. Everybody acknowledges that. There hadn't been a notice of appeal filed yet, though, which is usually the first step in removing jurisdiction from the district court, right? And then it's actually the docketing that deprives the district court of jurisdiction, correct?
That's correct.
That kind of goes back to my original question about jurisdiction versus procedure. But had the notice of appeal already been filed, then Mr. Ney's alternatives at that point would be to attempt to raise ineffective assistance of counsel on the direct appeal, at which point he would have been told, we don't let you raise that for the first time on appeal, or to file a motion for a remand for a Van Cleve hearing, right?
And that's what the district court and I believe the Court of Appeals indicated, but I think that's
Yeah.
that's the problem with the process.
I understand,
Where-
there's a process problem, but now we've had a hearing on the merits of ineffective assistance of counsel, correct? We've had, in effect,
Well,
what Judge Burgess
and-
called it, a Van Cleve hearing, right?
And we were successful. So at
Right.
some level, it may seem ridiculous that I'm making this argument.
Well, I'm
because
asking
we-
what you want as a result.
What I would
given
like
what's
is
happened.
I would like for the court, just as they did in Berry, where there's a judge-made rule like a Van Cleve hearing, and there's a statute that speaks otherwise, to follow the statute. The statute indicates that you don't. It tells you when you get a lesser included offense in Berry, and we had a judge-made rule on felony murder that the underlying felony had to be weaker and conclusive. The court digested all of that and went with the statute. Said we've got a statute here.
So your
We-
position today is that we should do away with the Van Cleve procedure?
Absolutely.
Okay.
To the extent it interferes with the clear statutory authority. The statute indicates you have 14 days, unless it's on newly discovered evidence. And if it's not based on, it's a calendar issue and the content of the claim. The district court has two issues to look at. Look at my calendar, look at the content of the claim. It's outside of 14 days, and it doesn't deal with newly discovered evidence. And again, it's important. These issues will be resolved. They just won't be resolved right now. And that's the way that the legislature has set this up. And in Baker, as we indicate, you can't have a 1507 unless you're under sentence. And there's a few things that we know for sure. This defendant was not under sentence, and this motion was outside of 14 days.
Right. We know it's not a true 1507 because of the requirement to be under sentence. We know it's not a true motion for new trial, or at least not a timely motion for new trial. I'm not disagreeing with you on those points. I'm just saying they're procedural, and I'm not sure they're jurisdictional. That's the problem.
Well, where is the authority to bring the claim? That's the jurisdictional issue. It's not, I can bring any claim I want unless you show me something that says that I can't.
Well, up to this point, there have been authorized ineffective assistance of counsel attacks during that period of time.
So-
And in fact, what we've said repeatedly, and what I think the statute and the rules say, is you can't bring them for the first time on direct appeal. So this wasn't on direct appeal yet. This was still in the district court. Why is it not to everyone's advantage to go ahead and get it done?
I don't feel that it's not to everyone's advantage. The problem is that the statute doesn't provide for it. That's what jurisdiction. That's what jurisdiction is. I mean, sometimes it might be to everyone's advantage to disregard the statutory authority. Okay, but we've been told that we can't waive those. The parties. Sometimes it's to the advantage to get things done now. But the problem is the statute doesn't allow for it. There's no jurisdiction. There are a number of cases where the court has indicated that the only problem is the parties can't waive jurisdiction. And I believe that's what this is. Otherwise, again, I'm left with the question that has concerned me and the state since the district court, because it's important to remember we lodged this objection at the district court level. What does the statute mean then? It certainly doesn't seem to just be advisory. And again, you will have your claims litigated, but in a timely manner. And you can forego your direct appeal if you feel as though ineffective assistance is the real issue in your case. You can forego your direct appeal, bring your ineffective assistance claim now. You don't have to wait. That's your decision. But unless there are any other questions on what I'll call the Holt issue, I'd like to go on to the sentencing issue. And I don't mean to indicate that it's clear in the sense that we, absolutely should be victorious, although I do feel that way. But it's clear to me when I read the record that the district court in this case seized on the sentence disparity issue. That was the issue. And it's my understanding that precedent from this court and the Court of Appeals indicates that you have a duty as a district court judge to articulate at sentencing what is the foundation for your departure. And we also have case law that indicates that catch-all phrases of taking everything into account, I find that that's not sufficient. We need to know what it is. Now, the Court of Appeals in this case never ruled on our issue. They never ruled whether the sentencing disparity issue is a substantial and compelling reason to depart. What they did is they told us that Mr. Ney filed a motion that contained more than that. I understand that. And they also indicated that at the sentencing hearing there was more discussion than the sentencing disparity issue. I get that as well. The problem is that the district court, when articulating the substantial and compelling reasons, seemed to have limited his reasonings to that sentencing disparity issue. And our argument is that is not a substantial and compelling reason. It has nothing to do with the defendant or the particular characteristics of the defendant. It has everything to do with what the legislature has set for the sentencing. And your dislike for that sentence should not equate to a substantial and compelling reason.
Didn't he mention a couple times his age? And a couple of times I understand that he kind of melded it all together and kind of did the disparity deal, but didn't he also cite public safety and age?
And I think that
and so how do we look at that? I mean, it wasn't as clear, crystal clear as you would like to see it, I suspect, but it's in there.
That must but I think that's where the cases indicate that, hey, we got to know. We have to know what your substantial and compelling reasons are. We are not going to go back and review the sentencing and say, oh, well, look over here on page 5, he talked about this, someone mentioned that. What are your substantial and compelling reasons? You have an affirmative duty to articulate it. And that's clearly where our position and Mr. Ney's position, the Court of Appeals position, they clash. How far are we going to go in and dig this up for you? Or are we going to do what you're required to do and what we've said you're supposed to do when you articulate those substantial compelling reasons? Unless the court has any questions on those issues, I'd like, of course, to address the public trial issue. I think it was Justice Johnson that Mr. Ney indicated, this decision, the content of this decision was something that was important in this case. I don't think that we can determine whether we need to open a hearing to the public based upon a future event and its importance to the case. That, to me, isn't the right answer. I think it was Justice Beyer that indicated that this was more akin to a sidebar. And I believe that to be true. There were no fact-finding process that was involved here.
Well, what was this proceeding? Was it a hearing on a Becknell contempt hearing? What occurred? I mean, it's kind of it's not so distinct from the trial, and yet it is part of it's something distinct to Becknell and trying to understand what his reasons are and make a legal determination on his unavailability. So what? I think characterize in your mind or in your words what this was.
I think that's what it was. It was a legal determination of whether this person was going to be found unavailable or not. And to a certain extent, it may have been done to protect the defendant, in that I know that it's with respect to the jury, but there are cases that indicate it is error to put someone on the stand that is going to invoke their Fifth Amendment right. I know that's not what we're talking about, but that's similar to what's happening here. I'm not going to confuse this trial, this jury process, with someone that we know from the preliminary hearing, and now I'm being told again, is going to possibly refuse. I'm not going to have this circus in front of the jury, and then the closure. I understand Mr. Ney read a portion of the transcript to you, but there's a reason that the state and the Court of Appeals independently have determined that the defense counsel requested this. And I think you need to also look a little bit further into defense counsel has told us this was his strategy with respect to this testimony. He was aware of how sympathetic this victim comes across. He knew what he was going to say, and he wanted this person removed from the jury's view, at least. And so, in order to protect the defendant, he doesn't care how this happens. I just don't want this testimony. And I know I'm jumbling the public trial and the finding of unavailability, but I think it's all together. It's all rolled up into one decision. I know the Court of Appeals ran through a number of contingencies. I believe that is, from my perspective, an appropriate way for the court to go through as well, because first we talk about waiver. And I don't know, Mr. Ney indicates that it's clear that you can't waive this right on behalf of your client. I don't think that's what the case law indicates. I don't think that it's clear at all. I think that the case law indicates that, in fact, you can. And it's more of an issue of the attorney having control over the conduct of the trial versus the guilt determination phases of the trial. I can't put it any better than what I saw in the Court of Appeals opinion when they cited to the Idaho Court of Appeals case of Overline. And if I may, a unifying characteristic of the rights requiring personal knowing waiver by a defendant appears to be that they are of central importance to the quality of the guilt determining process and the defendant's ability to participate in that process. On the other hand, the absence of the public in the particular case does not necessarily affect qualitatively the guilt determining process or the defendant's ability to participate in that process. I think that's a pretty good way to put the difference between the right to counsel, the right to a jury trial, the right to a public trial. And that's why, although case law indicates that this issue is subject to structural error, they look inside. Well, what actually happened here? Was this evidence, was the courtroom closed during the presentation of evidence, or was it something else? Was it a partial closure? Was it a total closure? We have the Waller questions, which indicate that chips away at a structural error. Why are we going, if a true structural error indicates the error happened and we're done? Waller doesn't do that. In fact, you don't need to look any further at Waller to realize that this is it's something less, because look at the remedy. Waller's important not only for what it said, but for what it did. It's a qualified right. Waller did not reverse the conviction. How important is that? Everyone wants to go, well, Waller says this, Waller says that, Waller says this, Waller says that. Waller's important for what it did. It sent it back for a new hearing on the suppression issue. It's a qualified right. It can be chipped away at under appropriate circumstances.
Any further presentation, counsel?
No, Your Honor, unless the court has any questions.
Any more questions? Thank you.
We'd respectfully request that the conviction be affirmed and the sentence be reversed. Thank you.
May it please the court. We first submit that the state has waived the argument on the Holt issue They've raised this as jurisdictional. That's what their brief says. They claim lack of jurisdiction. And unless this court is, at this point, willing to find that this is a jurisdictional issue, which is in clear contravention to Kirby and Kingsley, which have never talked about this as jurisdiction, then there is no issue here for the court because the state didn't raise it. As to, and again, as I told Mr. Loudon before we started here, well, what is it? Let's go back and I get a second chance to do this hearing. I mean, what is the point of that? Is this really, they're just asking for an advisory ruling of this court? That's what it sounds like to me here. But I would submit if this court says, yes, Mr. Loudon is right on this, then I get a do-over. Is that, perhaps I should be arguing his point. As to the sentencing issue, the Court of Appeals was very clear and listed in its opinion the 4 issues I raised on the downward departure motion. And said that the court, in making the ruling, talked about more than one of those issues, and said in its ruling, take into account the nature and circumstances of the crime, the history, character, doing the sentencing. The court says, yeah, principally I'm relying on something, but he talks about these other issues. Are we really going to have a standard that we measure how much time the judge spends talking about a particular issue as to whether that's the issue he's relying on or not relying on? And to go back on... Yeah.
Whose burden is it to make certain the trial judge gets the appropriate findings? You know, we've said, yeah, we put that burden on the court to make the findings, but we also put the burden on counsel to complain if they think they're inadequate. And so in this case, would it be the defense burden to make certain that there was the articulation of sufficient factors to support the downward departure?
Well, I would suppose it's also the state's burden to say that as well. If they're challenging it, I would say this is their burden in this case. But finally, just concluding with the whole issue of the hold argument, you know, let's remember what happened here was my client was dissatisfied with his counsel. Then I entered my appearance, again, after the 14-day time period had lapsed, but well before sentencing or before sentencing. Are we really going to force a defendant to say, I can't raise these issues in a motion for new trial, or in some way prior to appeal, even prior to sentencing, we're talking about, prior to sentencing, because I have an attorney who I'm saying is ineffective? I mean, that really is the catch-22, isn't it? We have an attorney, trial attorney, who we're saying is ineffective, but we're saying he has to raise, because it's pretty tough to get an attorney in 14 days, a new attorney, he has to raise his ineffectiveness for the motion to trial. I think that's requiring more than a young defendant like this can do. And so I think that's why we have these kind of cases like Kirby and Kingsley, you know, not marrying us, binding us to that 14-day rule at times, and considering this as a post-conviction proceeding.
You did argue ineffective assistance on direct appeal, correct? I mean, you did bring the argument.
Right.
So, I mean, that kind of takes us back to what kind of remedy the state should have at this point. I mean, you attempt to raise it on direct appeal, then we respond either by saying you can't do that, or here's a Van Cleve hearing on the issue because it looks like there could be something there. Or we decided on the merits because we've got enough in front of us already.
Right. And Your Honor, I think if you look at this case uniquely, we're raising the closed courtroom. The companion issue is the attorney didn't prevent that from happening. This is where really the ineffectiveness claim and the substantive claim, if we call it that, are married. And the same with the issue of the confrontation claim and the ineffectiveness claim. These are really all of a part that really make sense as one appeal and not two.
How far are we being asked to extend the statute? Do we extend it just for IAC claims? or are you suggesting we go farther?
Well, certainly a new evidence claim, the statute even contemplates.
I understand that, but that's, what you're asking us to do is not in the language of the statute, as I understand it. So I'm asking you how many different types of claims would you think we should allow to be raised outside that 14 days besides ineffective assistance of counsel?
I think typically the Van Cleve hearing has been limited to ineffectiveness claims. Matters that could not be raised directly on appeal that relate to the constitutionality of the conviction. So I guess other than new evidence, I'd be hard pressed to come up with other kinds of claims other than ineffectiveness.
So what do we do about the plain language of the statute?
Well, again, if I had been in the case several weeks earlier, I could have asked for an extension of the time of the 14 days. I understand what the statute says, but again, we have the court being able, in many instances, to treat certain types of proceedings, even from pro se litigants, and in a sense, that's what Mr. Reed was until I entered the case, if he had ineffective assistance of counsel. We have many kind of situations where the court has treated certain claims as, oh, we're going to treat this as a 1507 or a 1501. So this is not unique, and there's a line of cases, as we've cited both in our reply and in our response to the state's motion to dismiss, of those cases. I think the statute can be looked at as not so restrictive as to have no breath for the court to say, we can consider it in these terms. I just don't think we can be, that the court should bind the proceedings in that way.
All right, thank you.
Thank you.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. This time the